Hello and welcome to the 3PB Family Team podcast. Today, Vanessa Meachin QC will be talking about the problems currently facing the family courts and discussing the role that arbitration can play in finding a solution for some private law cases. We hope you enjoy listening.
We have now moved from unprecedented times to living the new normal, some weeks after lockdown on 23rd March 2020. We have a better sense of what has been happening in private law family cases. The collective view of the 3PB Children Group is that in certain courts, non-urgent private law cases are being adjourned with no date set for when they may be heard. Given the inevitable pressures facing the family court system at this time, matters will be listed according to their urgency. Whilst recognising in private law cases, as it is in public law cases, that the welfare of the child or children is the paramount consideration, children in private law cases are most likely still to be living with one parent and unlikely to face the acute welfare issues associated with children who are in the public law proceedings. It is reasonable to proceed on the basis that priority continues to be given to listing of public law cases. This was reinforced by the summary produced by HM Courts and Tribunals Service, headed Summary of Family Business Priorities, previously agreed with the President of the Family Division, April 2020, which describes, insofar as it relates to private law work, the following categories. A. Work that must be done, namely, private law children urgent applications, for example, child abduction orders, including tipstaff orders. B. Work that will be done, namely gatekeeping and allocation referrals. C. Work that we will do our best to do, namely other family law, private law, orders, documents and emails. In an email dated 6 April 2020 from the Central Family Court, all final hearings listed in April were to be reviewed, and only the ones that were perceived as genuinely urgent were to be kept. Central family users were being strongly urged to take steps, amongst other matters, to make every effort to compromise and to consider alternative dispute resolution possibilities. In Birmingham, on 6 April 2020, court users were informed that 82% of private law cases were being dealt with by magistrates. As magistrates were not working at that time, the court was looking to see whether the district judge team could be assisted by some deputy district judges. Our feeling is not much has changed. In guidance dated 25th March 2020, in an email, the designated family judge in Worcester explained that as magistrates carried out 87% of the private law work in the counties of Herefordshire and Worcestershire, and that there was no capacity for the paid judiciary to take up that work. Consequently, private law cases, save for those involving a direct threat to the child, were to be adjourned to administrative list at the end of the current lockdown period. All new cases were to be placed in that list. Thus, private law cases in the lockdown period were only to be dealt with where they were involving genuine emergencies going to the immediate safety of a child. Whilst these are just some examples, these are indeed large court centres presently not able to offer members of the judiciary, including magistrates, to deal with private law cases. While certain courts in certain areas of the country will be continuing to deal with private law cases, our experience is that this seems to be the exception rather than the norm. What is the solution? At a recent seminar held over Zoom by IFLA on 27th of April 2020, the President of the Family Division explained that the courts were facing, as we anticipated, an enormous backlog, coupled with the likelihood of an upsurge in private law cases once the present restrictions have listed. He was clear that there was a lot of dispute resolution to be undertaken and that the courts needed assistance in dealing with the backlog. He ended his message with his congratulations to IFLA and considered, as he described, that arbitration had come to family law and we needed to embrace it. Another speaker explained to us that we must be alive to the fact that if parties do not explore other means of resolving their disputes, courts may require them to do so by the courts exercising their case management powers and requiring parties to explore alternatives. There is an obvious benefit, it seems to us, in exploring alternatives at this time of resolving disputes in private law rather than solutions through the courts, which may take many months to come to fruition. The advantages of arbitration for the right case and the right clients will be to provide the parties with a determination which is legally enforceable and binding. It is likely to take significantly less time than contested court proceedings. The parties themselves, guided by their lawyers, will be able to select the person that they wish to arbitrate their dispute, and in the absence of agreement, the arbitrator can be selected by IFLA. The parties are able to own the procedure to a far greater extent than is possible in court proceedings, and are able to tailor the process to their own needs. The issues may be determined all at once or sequentially at specified periods of time so as to permit negotiation and settlement of other issues in the interim. The parties can, by agreement, appoint relevant experts to assist in the determination of their dispute. The family arbitration system is completely confidential, subject of course to the usual exceptions in relation to safeguarding and protection from harm, or where there is an overriding obligation in law to disclose. The appointed arbitrator alone will deal with the dispute from start to finish. This has the additional benefit not only of continuity of tribunal, but also that the arbitrator should be able to be available promptly to deal with issues as they arise in the course of proceedings. The parties are able to retain their lawyers throughout the process for advice, preparatory work and representation at meetings. The courts have made it clear that not only will they approve IFLA arbitral awards or determinations, but they will also uphold them. Once the choice of arbitrator has been agreed, the parties through their solicitors will be required to fill out a form which is submitted to the arbitrator for screening purposes, including safeguarding issues, because of course not all cases will be suitable for arbitration, particularly where safeguarding is being raised. The arbitrator will be able to identify to the parties' solicitors as to whether the case is indeed suitable for arbitration. If it is, the arbitrator will consider next steps. What are we doing here at 3PB? 3PB Family Team is working with a panel of arbitrators wholly independent of 3PB. 3PB has the technology, as shown in the Remote Private FDR Hearings initiative, to offer arbitration services to its solicitor clients. The 3PB Family Team is able to offer remotely a hearing room for the arbitrator, the parties, solicitors and counsel to be together. It has the facility for each party to be in their own room remotely with their solicitor and counsel. This would be locked so that the other party could not enter. Controlled and organised remotely by a member of staff at 3PB neutral to the parties. There is, of course, the corridor where representatives can come together remotely to continue their discussions, and of course the facility for everyone to meet up again before the arbitrator. We hope very much at the 3PB family group that you will take the opportunity of looking at this 3PB initiative, understanding, as the President has done, that arbitration's time has come in private law family disputes. We invite you to embrace it.